1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 charges in that criminal complaint that does contain 38 or 36 counts, criminal counts, but 12 of those counts relate to defendant Robert English. We are here today for the court to hear any arguments to supplement the briefs, because again, this is I want to say a complex, or it has a lot of facts and things alleged in the criminal complaint as well as in the arguments. So I am going to start with Mr. Harrington. This is your motion. Again, I have thoroughly read your brief along with the criminal complaint. As it relates to this case and any argument, what would you like to state?
Judge, nothing. I'll rely on my brief, except anything that I quoted in the brief, cited in the brief, was based upon either a review of the cases that I cited or the jury instructions. I'll stand on the brief. Thank you, Judge.
All right, thank you. Mr. Schmidt?
There's a reason why the test for adequacy of a criminal complaint is described as common sense and not hyper-technical. If the complaint was only one sentence long and the one sentence was 4 people who reside in Burnett County reported their house was broken into, damage was caused with the breaking in, and stuff was stolen, and the stolen property from all 4 were found in Robert English's bedroom, that would be an adequate complaint. This complaint actually contains that information as well as a plethora of other information. The court has already found probable cause for all 12 accounts when it issued the arrest warrant. Attorney Harrington has not pointed out anything I think the court missed. Thank you.
All right, Mr. Harrington, any reply?
No, I'll stand on the brief.
All right. Again, the court has reviewed both of the briefs that have been submitted by the parties in this case. First, the court must address the issue of the arrest warrant and the argument that the court has heard that the court found probable cause when it issued the warrant. This is not entirely accurate. The court did find probable cause that a crime was likely committed or probably committed, but not that a felony was probably committed or which of the crimes could have probably been committed. And there's a difference. A preliminary hearing would determine whether or not there is enough facts or evidence alleged, even with inferences to the state, to determine whether a felony was probably committed. Whether or not the burden has been met with an arrest warrant of a crime being probably committed, it's determined about within that criminal complaint, which would be text messages between the co-defendants. Those written communications among the parties discuss potential burglaries, which then would give the inference or the connection to the criminal damage to the property and perhaps possession of stolen property or misdemeanor theft, moving of property. However, those conversations, specifically in reviewing each of those texts very specifically, those conversations do not implicate Robert English in any of the burglaries, which would then connect to the criminal damage to the properties, only that they may relate to the probable possession of stolen property or movable theft or theft of movable property. So in the court's review, I cannot find the evidence or the facts presented in the criminal complaint to connect Mr. English and the commission of the burglaries and the connection to the criminal damage to property. Could Mr. English could he have possibly known about the burglaries? Yes. Could he have possibly helped in committing those burglaries? Yes. But in the review and as the facts and statements and the specific details are laid out in that criminal complaint, reviewing the criminal complaint and what's laid out in detail in that criminal complaint, it would only be speculation or conjecture because of the close connection Mr. English has to the co-defendants. One of the co-defendants is his girlfriend of a significant long period of time, and the other co-defendant is her brother. But there is that close connection in those written communications as to the likely stolen property and it being in possession of or going to be or something to be done with, probably with Mr. English. There's a connection to that, even as stated in the criminal complaint.
All right, everyone, buckle up because today's courtroom showdown is an absolute masterclass in legal precision. We've got a judge who reads every single word of a police report like she's grading the SATs, a prosecutor sweating bullets because half the evidence isn't on the record, and a defendant who might just dodge the felony charges by a technicality. This isn't your average court drama. This is where facts on paper, and only facts on paper, decide someone's fate. Stick around, because we're going to dissect every jaw-dropping moment where the law collides with common sense, and yes, the stakes couldn't be higher. Let's dive in. Asterisk.
Reviewing and looking for the conspiracy. Conspiracy requires a mutual understanding to achieve a shared criminal goal and to work together to carry out that criminal plan. There must be some type of either words or actions or intent by the defendant to complete that crime in the criminal complaint. As again, it is laid out and described in specific detail. The court can't find anything that indicates a conspiracy without having mere speculation or conjecture. This is insufficient for the court to link the defendant to the crime of burglary or to the relation with the crime of criminal damage to property. Although the state does correctly state that conspiracy does not require the co-conspirators to have an explicit or formal agreement, meeting, or even know each other, there still must be more than speculation or strong opinion or belief to link the parties to committing a crime like burglary or criminal damage to property. The details and the specifics as related to the burglary and then the criminal damage to property as outlined in that criminal complaint in the court's review does not provide sufficient inference to connect Robert English to those acts. This is in contrast to the court's review with the allegations of the possession of stolen property, theft of movable property, those and the conspiracy to commit the misdemeanor theft as a party to a crime with that movable property. The court determines that that criminal complaint contains enough facts and specific details to reasonably believe and probably believe that Mr. English did commit or co-conspire to commit those crimes, allowing those charges to move forward. But with regards to the burglary and the criminal damage to the property, the court cannot find enough to connect even with an inference without mere speculation or conjecture to connect Mr. English to those crimes. So I'm believing you understand that the court is saying with regards to the charges, the court can only find enough to connect as it relates to the conspiracy to commit misdemeanor theft as a party to a crime with the movable property. So I believe that is only counts 6, 15, 24, and 33. Mr. Harrington, you look like you want to say something.
I haven't thought through what I want to say, because I think those are all misdemeanors at this point, aren't they?
They are.
I guess, as I recall the rules, Mr. Schmidt has the opportunity to amend the complaint
He does.
rather than a dismissal. And I guess I want to know how long it's going to take him to amend the complaint.
Here's where it starts getting interesting. The judge lays out the 38-page criminal complaint, with 12 counts specifically against Robert English. And right away, you notice Mr. Harrington, the defense attorney, basically saying, "I'll rely on my brief." That's a bold move, and it immediately sets the tone. This hearing is going to hinge entirely on the paperwork. No theatrics, no side arguments, just cold, hard facts. The judge is letting everyone know she's done her homework, which is a subtle but powerful signal to the prosecution. If your case isn't airtight, you're going to feel it today.
And where we go from there, suggest that maybe the court set this for a status.
I'm not going to amend the complaint. We need to do the prelim. We need to get this case moving. One of his co-defendants has invoked speedy trial.
Fair enough, we'll set it for preliminary exam. I have time. If the court is finding that everything except 6, 15, 24, and 33, the complaint lacks that, the motion is an attack on the personal jurisdiction. I think there has to be an amended complaint. These are misdemeanors. We're not going to have a preliminary exam on misdemeanors.
We would not.
I thought the court dismissed the crim damages.
And the burglary.
So the court found probable cause to believe that Robert English was knowingly in possession of stolen property from the theft, which is an essential part of the conspiracy, but would not find the burglary and crim damage that were necessary for the theft, even though the conspiracy jury instruction says he doesn't need to know about those or be part of them.
I think
That's
that's
my
precisely what the judge found, and I agree with
That is
that.
exactly what I found in the review.
You all have the mutual understanding of the same crime, just a criminal purpose. That's why the jury instruction reads that.
again, I can't find in the facts, especially in looking at the text messages and the communications between the co-defendants, that Mr. English was involved in the criminal purpose of the burglaries. Did he possess the stolen property? Probably with the facts.
That's what I'm getting at with the conspiracy in this. It's really all or nothing. If the court believes that he was part of the theft, as in he knew the property was stolen and possessed it, he's also party to a crime conspiracy on those others. It has to be all or the other when it's all part of one scheme.
But not necessarily. There could be a scheme. I don't see a scheme here. I see any individual could receive stolen property from their friend Joe. Joe could say, hey, dude, I stole this. I got this. Let's sell this. Doesn't mean that the guy was a part of the decision to steal the property.
Then the court couldn't bind over on the theft because that has a knowing element too. That's the problem.
Well, I find that there's probable cause to believe that he was in possession of stolen property and knew that it was stolen.
So is the court actually dismissing all counts then? Because we didn't charge receiving stolen property.
Again, you can amend if you wish. I'm saying there's enough probable cause to believe a crime was probably committed. What that crime is and how it's laid out is for the state to prove. I'm seeing that there is at least enough to determine probably he was involved in the conspiracy to commit the misdemeanor.
Here's a fun nugget for all the legal nerds out there. The judge compares common sense to hyper-technical legal scrutiny. She says, even a one-sentence complaint can suffice if it clearly lays out the facts. Think about that. The difference between a weak case and a solid one isn't how clever your attorney sounds, it's whether the facts are actually written down. Meanwhile, the prosecutor is probably gripping his notes like a life raft. You can almost see the panic creeping in as he realizes the felony case could crumble if the details aren't perfectly documented. Asterisk.
Well, to have the stolen property, he had stolen property. So if you want to, I can dismiss all counts.
I am
But the
not
state-
amending and receiving stolen property. If the court is not finding probable cause for all three counts, that's what I'm checking.
Mr. Harrington, if he does not want to proceed with the other misdemeanors that are
I
stated.
didn't charge receiving stolen property as a thing. The court's saying it's only finding probable cause for something I didn't charge is what I'm hearing.
I think the judge addressed me. I'm to answer the question. that the
Yes,
court
Mr.
posed.
Harrington.
As I mentioned, the rules require or give the state the opportunity to amend where a court finds that there's not facts sufficient in the criminal complaint to impose the jurisdiction of the court over this particular defendant. The state has that right by statute. What Mr. Schmidt is arguing, the court decided that there aren't facts sufficient to connect those inferences that they want to have connected for the felonies. As I understand the court's decision, the court found that there is no basis for the conspiracy as it relates to the burglary and the criminal damage to property, but that there is for count 6, 15, 24, 33, those are misdemeanors. If Mr. Schmidt wants to amend, fine, but I don't view that we need a preliminary exam for those particular crimes. They're misdemeanors, even if it's
We do
misdemeanor.
not. And that's the court's view is I find probable cause that a crime, a misdemeanor crime was probably committed by Mr. English. There is definitely enough there to connect that. Whether, and you agree, Mr. Harrington, yes, you're nodding your head up and down.
Yes.
Yes, you agree. And even in your brief, you agree that there is enough to say Mr. English probably committed.
There's probable cause to believe.
Correct. There's
Set
probable
forth,
cause
right,
to believe
yeah.
that he did commit misdemeanors. Whether or not the state wants to continue and to pursue the misdemeanors as charged, that's a determination for the state.
Correct.
The court is not dismissing those misdemeanors. As stated on the record by Mr. Harrington, and I have them written down somewhere as to what they are. But I don't have them, I don't know where I wrote them down on which. 15, 18, no,
6, 15, 24, 33, Judge. Those are the ones you recite out of the record.
correct. Those misdemeanors stand in the court's review of determining probable cause that a crime was probably committed by Mr. English. The other allegations, the court cannot find any connection as laid out in the criminal complaint. But again, the state has the ability to find other information or to put other things in that criminal complaint that would tie it to a conspiracy for criminal damage or conspiracy for burglary. I just can't find it. And I'm going to tell you, I reviewed that 38-page criminal complaint at least 3 times, perhaps more.
Here's the issue of confusion I'm having. I'm hearing the court saying it's finding probable cause for the counts that are misdemeanor theft, movable property, where the state's alleging that Robert English took property out of the homes during
No,
the
that is
burglary.
not what that is not what the court is saying. The court is saying, just like any preliminary hearing, when I have
This is not a
Mr. Schmidt, it's
And here's the moment where the courtroom tension hits peak levels. The judge explains the crucial difference between probable cause for any crime and probable cause for a felony. Basically, she's telling the prosecutor, I can give you a misdemeanor, but your felony? Not happening. You can feel the frustration building. This is a textbook example of how a case can hang by a thread. The lesson? The law demands specificity. Suspicion isn't enough, and even if the evidence is strong in theory, the paperwork has to reflect it. This is what makes preliminary hearings so fascinating.